Let's start with Chapter 7. Post-bankruptcy filing, you have about 45 days after you have a creditors meeting. The trustee is going to meet with you and talk to you about what the assets and debts are of the estate. It's a very simple meeting, but very scary because nobody likes to be under oath, and so it's scary for everybody when they're doing it. But that Chapter 7 trustee's job is to administer the estate. So he's basically telling you what you're going to do with stuff because he's in control and he's in charge. Your attorney's there to help you go through that process and to deal with some of the fear of the process, assess whether the assets are exempt or not, and how the trustee can administer those assets and what the interplay is between you and the trustee on getting the estate administered. But Chapter 7 is a fairly quick process unless you have some really complicated behind-the-scenes issues. That's why it's really important at the beginning to talk to your attorney about what those issues might be for you to make sure that something doesn't jump out at you after you file bankruptcy. At Chapter 13, take everything from a Chapter 7 and add to it a plan process. So you're going to be proposing to your creditors how you're going to repay them over the period of a 3 to 5 year plan. Now there is a Chapter 13 trustee, but he is not in charge of the estate the same way a Chapter 7 trustee is. He's there more to receive money to pay out to creditors, but he's not there to necessarily make the decisions about what you're doing with the estate, and he's not there to administer your plan. That's your job in Chapter 13. He's more of an overseer and a receiver of funds to pay out to creditors. And ultimately in a Chapter 13, that process is a 3 to 5 year plan, so it's a much longer period of time that you're paying out your creditors. Now Chapter 11 is similar to a Chapter 13 than it is a Chapter 7 in that there's a plan. The process, though, is much more cumbersome because a plan is much more fluid on what you can put into that plan, and there's no trustee like there is in a Chapter 7 or in a Chapter 13. So you're calling the shots on what you're going to propose to your creditors, unless you're really slow at getting stuff done, because then your creditors start attacking you and start causing you to have to call shots when you don't want to. So a proactive debtor is always going to do better in bankruptcy than a reactive debtor. So you want to be as proactive as possible in the process, making your own decisions about what your goals are and advancing the process along as quickly as possible, because that will be more productive and, frankly, less expensive for you to be proactive about what you're doing.